I love a buttered biscuit.
Oh, good evening, everybody. Good evening. Oh, yeah. I'm going to bring this thing up real quick. I've been recording this in the background, but I had to have some dinner and take a little bit of time and spend with my wife. So I'll be updating the audio probably tomorrow. So if the audio sounds a little bit off, don't worry about it. I'm going to update that tomorrow, make it sound so much better than it currently does right now. Good evening, Star Z. Good evening. Yeah, we'll go ahead and get this thing started and get it planned so that way we can get sort of caught up with it. This is her motion hearing. I believe this was recorded earlier today. It's not a live feed. It was brought to you by the Court TVs. So thank you, Court TV, for capturing this. Like I said, I'll be editing the audio later later probably night after the men's stream tonight, which will be over on this channel. And I'll be sending everybody over there directly after that. I didn't have any time to send any invites out to any guests, so it's going to be just me right now. But whenever I have a chance to update the audio, I may review it a little bit later on in the week. So if we don't catch the whole thing tonight, well, she's getting a little chunky, isn't she? Prison food will do that to you, I guess. You know, lack of alcohol. And it's been over almost 4 years now since her arrest. So this has been going on for a while. We'll get caught up a little bit here. So she's getting sworn in, calling the case.
Ma'am, good morning. Could you please state your full name and date of birth for the record for me? I do see that we have a representative from JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
I'm going to speed up a little bit.
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good.
That's
JA. Things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, don't need to stand, thank you. The defendant's temporary motion for reservation of proposed cost to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024, and received July 29th.
Thank you, Silver Eagle. I appreciate it.
I have reviewed all of those motions. All three motions
we're going over this
with regard to the investigator, witnesses, and deponents.
I'll catch you in chat here in a second.
How to calculate is unknown. As the depositions, the date are to be determined, and the amount of transcripts are unknown.
Good vibes, Kimberly.
Your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is, if we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions, we would be happy to send her a copy, or send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it.
They're helping her out.
Position with regard to those three motions that the court just identified.
For pro se's.
Okay.
They've got it all planned out.
Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no,
they're going to raise it to $10,000
for reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them.
Congratulations.
When you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as right now, I don't know who it is that you're seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions? And do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date once I have that information to revise them.
I'm giving you the opportunity to refile. Yes, ma'am.
Thank you.
With
What do you
regard
say?
to the defendant's motion for reservation of proposed costs to
Break down that volume a little bit.
With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense and trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor, again, the issue here is with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motion that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required. For
we can't guess.
Expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the
be specific.
that JCS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024 and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when in the situation where a pro se defendant who is elected to represent herself decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is essentially not to get involved until the defendant says, I no longer want to represent myself.
Yep.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel. Decided by Paul versus State, 152, 3rd, 635, at pinpoint 641.
No right to standby counsel.
In 2014, citing to the Florida Supreme Court case, Jones v. State, 449, Southern 2nd, 253, at pinpoint 258 from 1984.
There she goes. You're on your own. You're flying blind now.
As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd versus State, 17 Southern 3rd, 275 at 279.
Just giving her the case law right there. Hey, how's it going?
Entered
Okay.
no request for standby counsel.
Just see. Denied. No standby counsel for you, sweet cheeks.
Questions, ma'am, as to the court's rulings this morning?
First of all, I do not look at my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. so I could have better explained myself and you could have had a better.
Good to see.
understanding.
Hey, Ressa.
So,
How you doing?
You denying my standby counsel, which thank you to him for explaining to me what specifically it is. I don't want to be pro se any longer, so I didn't want to be pro se in the first place. And again,
But you did by your actions.
Unlawfully denied me, or didn't even suggest an evidentiary hearing order for me to avoid or try to go about a solution or remedy to even understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary
Denied.
hearing, that seems to be in the realm of a Ferretta inquiry where
I believe
a
the
criminal
judge
defendant
is
is
going
seeking to
to
represent
make this
themselves.
case
And I would inquire of that person and have
as
an
complicated
evidentiary
as
hearing
possible.
as
Yes,
to the rights and
I
remedies that
agree.
you were
I
forfeited
agree, Denise.
and the pros and cons of proceeding representing
Completely
yourself
agree.
and benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
Yep. You
My
lost.
understanding was the hearing, the Ferretta hearing is regards to competency as opposed to having understanding before you take someone's right away.
Ferretta pertains to a criminal defendants seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that
There
were
you go.
provided in the 16-page order.
Busted.
Yes, I understand. It was
No, you don't.
the day of that I was explained most of all of this, and as opposed to prior, so I.
Lie. Not true.
Could happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this.
She's confused a lot.
Understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So the evidence.
Nope.
Evidentiary hearing.
Nope.
Thought would be
That's wrong again.
collaboration of.
And that's her own fault. Ignorance does not allow you to be innocent. You forfeited your right to counsel by your actions.
Because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the.
Doesn't need to.
To avoid any of this with me sitting in front of.
Let's see. No, it does not.
16-page order. I listened to every audio hearing.
Has
specifically provided
everything in
dates,
there.
Times and words that were specifically said at
Now,
particular.
but you may be able to turn
involving
closed
yourself
captions
and
on
counsel.
mine.
I also made reference in the 16-page order to statements that were made in your letters.
You should be
I've read
able
everything
to.
in the court file. I've read every single
I
letter.
think
and I've
it's
listened to every single
allowed.
audio. That decision was not made lightly, and it took a lot of time to make that determination and that
But
decision.
don't worry, I'm
Wow.
downloading it, recording it, and I'll
Whatever
have
stands
those captions
remains.
on for
We're not
that.
gonna revise its findings or
So
its determination as
you'll
your
be able to
forfeiture, and
you'll be able to
alternatively,
hear the
by
audio
virtue of
much
the
better.
conduct identified in that order.
Yeah, she screwed up.
I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys.
No.
After reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have
No, not a problem.
of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
Yep.
And I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Yeah. There's a big difference between your opinion and what the law is. Your opinion does not matter to this judge. I think the judge has made that obviously very clear. Your opinion, sweetheart, does not matter. This is the way that I wrote my order, 16-page order, based on telling you in the first place, we're not going to allow you to go through every single attorney that we have. Understandable that some of them can work out because they're representing a witness or they're representative of the deceased, or they were a prior representative of you. So he made his basis on telling her, no, you will not be able to get another attorney. This can't continue. And I'll tell you again, this cannot continue. And she ignored what he said. Was difficult with her attorney. The attorney had to leave because she became a difficult, very difficult client. And I would love, it would be amazing to hear what these attorneys had to say about how horrible of a person that she was acting towards them and unrealistic goals that she set. That's what I'd like to hear.
My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So
3
the trial
weeks
will take place on October
Wow.
7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th.
Tuesday the
At
26th.
9 a.m. Yes, sir. That's Thursday.
Tuesday the 26th, 9 a.m. Ooh. Damn. They're trying to move it along. Oh, yeah. We're there to help.
Ms. Boone,
The
that
world
will give
needs to
you additional
learn.
opportunity to prepare
Yes.
for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days.
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of these state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth of
It's
scope of what
important.
was reviewed you, but
20 hours.
reviewed you based on
That's a lot.
representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list for your exhibits for trial.
Crazy.
As far as
20
providing,
hours.
A list of the specific items that the state seeks entry of.
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense.
Yeah.
And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider.
It has to be valid stuff, though.
Almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial.
Yeah.
And I think that's important to do that so that Ms. Boone has the opportunity to view those in court. So that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
Yeah, they're cautioning him really quick.
That's it.
so I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections. And
That's right.
go from there.
Okay.
Don't go at her hard like you would another attorney.
It's viewing, for lack of a better word, or for the list to be provided.
For the list in the USB.
Okay, we're gonna make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for some.
Pack your bags.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital,
Is
that's
it
not forensics,
storming?
CSI, or something
They're in the
that's
middle of a storm.
tangible, will be provided to you on a USB drive.
Yeah,
We also will have a hearing where
it's
all
heavy
the evidence,
storms, right?
including any
Right.
digital,
At the time that this was
electronic evidence, or any
recorded,
tangible evidence, CSI
it was
materials,
pouring
will
down.
be shown to
They're in
you
the middle of a
or played to
hurricane.
you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. Then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
Right.
So it's not a matter of any type of confidentiality, it is all done in the courtroom with everyone?
It would be
Yeah.
in the courtroom, correct?
Yeah.
Like news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed. So as to
That makes
further
sense.
prevent intimate details of the case being released prior to trying.
Oh no, they came in at the last minute.
Ms. Boone, not to turn the page completely, but I think it's perfect for this discussion, has indicated through.
So from what I understand, and I'll address this really quick, Brandon. So what happened is that this was supposed to happen. This hearing was supposed to happen in early in the morning, like 9:30 in the morning. This was pre-recorded, and I did not receive this until about 4:30, 5 o'clock this evening. And I immediately started recording it. So I'm upgrading the audio on it so it'll be a little bit smoother. And I'll also cut out any really long breaks in it, so it should shorten it down quite a bit. Should have that done possibly tomorrow. That's sort of the goal, is to, probably get that processed this evening. After the main show tonight, right here at 9:30, we'll be starting. But yeah, so everybody just know that it's going to get updated. But yeah, it's just because they're in the middle of a storm. That's why they had such a late start on it. They got the cameras in there, they recorded it, they premiered it, they probably did very little editing to it, and this is just the update to it. So there'll be a better part of this tomorrow that I'll go over.
Some counsel that had met with her recently that she wants to talk to the state out of the jail, and I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos. Perhaps a different suggestion, especially since she has an investigator from prison break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence
There you
on
go.
their own in the jail, and we're not publishing all the digital evidence here in open court.
That's not a bad idea. That's really not a bad idea. So they're basically saying this is what we plan on using in court. These are the items that we want to present. And if we show that to make this a little bit easier on her, so she's not having to go through tons and tons and tons and tons of footage, all she's going to have to review, she's not going to be surprised. All she has to review is the stuff that we plan on bringing into court. That's very accommodating. They're not trying to play an I get you or I got you. Like they're saying, this is what we plan on using. So that way she has a chance to review it and make any sort of case that she wants to. We're not going to tell her what our case is, but we'll point her in the direction so she doesn't have to go through every single thing. That's pretty awesome.
That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise to autopsy photos, so on and so forth,
Right.
without exposing all the digital media to the public.
That's
As far as
pretty good.
physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions. And then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that, because this is in the context of plea negotiations potentially, I would be out there, Mr. Cashore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator, or she can review it with us, being present.
There we go.
That way the digital evidence is now open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That's correct.
So I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media.
Good luck.
I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is
Was suppressible.
that I should have
Truth.
some right to privacy in reviewing my the evidence. So I didn't know if
Sure.
my investigator and I are able to collaborate prior and review and then come to court with everything finalized and ready to go with answers.
But you also have to understand, I'm not in Orange County.
Your investigator to
It
address
doesn't
the
matter to
question.
me.
It's just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera.
He's explaining
will
it
be
again.
Addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it. But it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI.
So he's talking about physical evidence, like a suitcase, that kind of stuff. Like he can't release a suitcase to her, or blood evidence, or if there was, a wallet or something like that. He can't release that kind of stuff. Any physical evidence, digital copies, pleadings, all that kind of stuff can be released to her because they can put that digitally, images, all that kind of stuff can be released to her. The physical documents she would not be able to touch. She doesn't understand what physical is because, well, she's never taken one, possibly.
I would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it cannot be transported anywhere other than here?
Because I cannot make a record anywhere else of
He's
what
an
you
idiot.
saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney
You, Jesus, what a waste of time. Hey, Roxanne, good to see you. Yeah, we're going through this really quick because here in about an hour and a half, we're going to be on this channel just doing something different. And this is just dropped today, like while I was getting ready to take dinner.
attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package. And if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Okay.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive of research, I don't know if I can make a call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So
Yeah, that's what he said, dimwit. He said, where if I can avoid having the evidentiary televised, I will do that. But, until then, just, he's got to craft the order for it. Be patient. Stop being a twat waffle.
if you could please look into that, because I disagree with the media being involved in that.
I understand your position. And again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from the dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. Yeah. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the
Tuesday the 3rd
examination here in court. At that time, the USB drive or the after our viewing here in court stays at your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all the digital and identify what it is specifically.
We are happy to defer to the defendant's wishes on
Hey, Roxanne.
that. And I want to have that discussion. It seems like we're turning to that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other.
So I think she may want to be trying to strike a plea with them. I think that's what it sounds like she's wanting to do. And they may just say, yeah, don't know. We'll see.
Okay, all right, ma'am, do you have?
Well, there may not be a hearing.
I
mean, there may not be a
You would
case.
like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by.
It depends on how difficult she wants to be. If she wants to be a real pain in the ass to them, like really difficult, I guarantee you that they're just going to say, nope, no deal. We're not going to play your game. And just tell her to go pound dirt.
The state.
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion we had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand.
That's pretty-
So would I be leaving with?
No, you don't.
evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
That's pretty damn straightforward.
To find my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't.
Doesn't matter.
I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously had worked on the laptop with USB drives that he has furnished himself, bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or procedure. I don't know who your names are from the jail. I do know the captain whom I spoke to the other day regarding my laptop, but I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to, who was it?
T. Giovanni?
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring it with me prior.
If I understand the jail.
I haven't heard any of anything being leaked from the jail.
The jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives in the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right.
Yeah.
It's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Yes, he did.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who?
There's-
What are their names?
There's multiple sergeants.
What are their names?
What are their names?
They're not given involved
Oh, see, she's making accusations, not giving out names. Oh, just ambiguous.
Or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I didn't get to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with, the implementation of your new SD drive.
Okay.
option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
by US mail?
Mhm.
Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate
Yes.
legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail, and Mr. Lane will thereafter file.
So to answer your question, you've been listening and making dinner. Congratulations, you're getting dinner. Good thing. I've been listening to making dinner. What happens if she gets obnoxious during her pro se appearance? Does a contempt charge get added to her sentence? I don't know. It very possibly could be if she gets obnoxious and gets difficult. The judge could remove her. In certain cases, judges have been known to gag people. I think he would probably avoid that because of how difficult that makes it look. And it seems like this judge is pretty much on board and fair with the way that he's treating her. He's treating her with very gentle kid gloves. So he's going to be very careful about it, but there's only so much that a judge is going to tolerate. And I guarantee you, as a pro se, she is going to push every limit that this judge has of him saying, enough is enough. You do it one more time, I'm going to hold you in contempt. I'm going to remove you from the courtroom and we will proceed without you. That's what they should have done in Darrell Brooks. I don't know if they will do it here or not. That's one of those you'll have to wait and see what the judge says, because I'm sure he'll have some rules for her to follow. So we'll see. Hey, King Paco, good to see you. I am good. I'm doing really good.
Be filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records, under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available.
She doesn't, in other words, she's saying she's not going to be able to roll around in, her ex-lover's clothes. That's not going to be provided to her. If she's looking for that kind of evidence, then she's going to have to be there for the evidentiary hearing, which is going to be held on the 26th. Because your landlord-tenant tribunals act pro se for the group. All these hearings I've watched has assisted you now how to act. Yeah, just act and behave accordingly. Don't become obnoxious and be very, very, very attentive. Pay very close attention what the judge says. Don't be thinking about your next answer. Respond to the question presented to you and nothing more. Always. I'm not an attorney, but that's how you handle these kinds of things.
Available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, is going to be a feat in itself. So I I want you to know if anything that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay, the court's going to follow the procedure as I outlined at the last hearing.
Yeah. So she's saying, I don't feel safe in jail. Well, that's part of being in jail. You're not going to feel very safe. You don't feel safe. Okay. You know, this is a predicament you put yourself in. You know, we're doing the best that we can. You don't feel safe. It's not like anybody handed you a drink. They didn't tell you, go ahead and drink up and, you know, make sure that, you know, you crash out early. They did none of that. Didn't ask you how you did it or anything like that. They are just going to provide the evidence of how this happened, their theory on it, and they're going to move to have you incarcerated for who knows how long. I don't know what their sentence carries, but she should not have done the crime. Well, and that's the thing. I mean, that's sort of what her plea is that, you know, this wasn't her fault. She's going to try coming back and claiming spousal abuse and all this other kind of stuff that she should have done early on. Whether her attorneys did this or not, all that I know is she's seen on tape taunting him while he's locked in a suitcase. She didn't let him out. That's no different than seeing someone drowning and making fun of them while they drown. And I don't think Georgia or Florida feels any different about it than that. And that's the way that they're looking at it. So, you know, it's by her inactive actions is what caused a lot of this that could have been avoided. It's not like she's a nice person. Her and her deceased boyfriend had a long history of abuse towards each other that led into violent communications and probably was not a pretty sight to deal with.
So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
Can caveat in that order be unless it hasn't already been done? In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court
There you go.
identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am,
Good.
after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th.
There you go.
So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I will be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline
Yes.
for the state.
So what he just said, and hopefully she's paying attention to this. I would think that she should be. Is they're telling her you're going to have an opportunity before the hearing. You know, they're going to sit down. They're going to go over whatever pleadings. They're going to try to get you the evidence, whatever they possibly can do to expedite this, so as not to waste your time. So you don't have to sit there in jail guessing about what's happening next. And all of this that's been happening. This is Sarah Boone on the screen. This right here is to get it set up just for her. They're being very accommodating, trying to make it as expedient as they can. They can't give her any legal advice. They're going to show her the evidence, and she'll probably ask a whole bunch of legal questions. And if they're smart, they'll just go, "We're not your attorney. We're showing you the evidence." And I have a feeling she's going to get very aggravated and probably get a little bit pissy about it because of her attitude currently, the way she has been acting.
State's investigator, your investigator, and yourself to meet to review the digital evidence would be no later than the close of business on September 3.
No later than, but she could do it before.
If the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get that.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Then you can do that. And like I said, Mr. J, if you could follow that.
Yeah, that's
just a
they could do this early
that would be
this
most
month.
appreciative. So, ma'am, under
So, keep this in mind. Can she, well, she can't offer a plea deal. She can ask for one. She could say, this is what I'm willing to do. And the state could easily say, yes. The state could say, we can put it down, and I'm just using this example. The state could say, we can put it down as time served. You take the guilty plea. And you'll have, time served, or you're going to have to do another 3 months plus pay restitution, which might be, at this point, probably close to $30,000 or $40,000 that she's in the hole, that, on her, just in JA's cost. Because if she's gone through that many attorneys, each one of them is billed 20 hours. You're looking at $9,000 a piece. So, you're pushing the point of, possibly hitting $100,000 that she would have to pay in restitution. And that would be part of her plea deal. And, she may have to serve a little bit more time, but could be out if she pled to a lesser non-guilty or any number of things. So yeah, the plea doesn't go out, and they don't bring that plea up in if she does continue and take this to trial. None of that can be held against her. Whatever the plea was, it can't be held against her, so they won't even mention what it was unless she brings it up. Do I think the judge will be present at the evidence presentation? No. The judge is not required to be there, because all parties will be there. They'll sign an affidavit saying that they were there. They'll have a court reporter. More than likely, she'll have to pay court reporter's fees if she wants to get a transcript. And they'll basically go through the evidence, do the plead hearing. She'll have her investigator right there with her. If she's asking any questions, he may be able to answer them for her. If she says, so what is this a picture of? He can tell her what that's a picture of. They don't have to give her what the case is that they're going to have against her. All they have to do is just be there. And the judge already said, as far as the presentation of that, they do have a scheduled evidentiary hearing, which is going to be where they will go over all of the evidence at the time, which is going to be September the 3rd. It'll be right after Labor Day. So Labor Day was on the 1st. That is whenever he had it set, because that's on Sunday. It follows because Labor Day will be on Monday. They'll have it the following Tuesday if they haven't presented the evidence before then, and she'll have had to sign off on it. So there's a possibility there won't be an evidentiary hearing if they can get through a lot of the stuff. We'll see. Those are things that we won't be privy to until after it happens. So this case could actually be pled out and settled, and she'll never have to go to trial. There is that possibility. It's happened before. With her attitude, I don't know if that's going to happen. I don't know.
Understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to going in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have a laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So
It's been explained to you a million times. See, this is the problem that they're going to run into already because she does not listen. This is the biggest problem that she has is it goes in one ear and out the other. She does not grasp what they're talking about. I've been able to understand everything that the judge has been explaining to her. Apparently she's not been provided with that capability. And this is probably one of the contentions that led to all the issues that she's had to deal with. I'm used to dealing with idiotic women. I work in retail, so I know that I can fix her. That's awesome. That's awesome. Good luck. Good luck.
rate restriction also that is being put on the laptop usage from 8 to 4.
No, that is not a great laptop restriction. That is the restriction that the judge put on there. He said that laptop will be made available from 8 to 4. That's it.
I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard
Because she's got to take a poop at like 10. She wanted to have dinner at lunch, and she's going to laze about. And I guarantee you, if I was in her shoes, I would be like, give me the laptop, give me the evidence. Let me sit down and review every damn bit of this. Of course, I would have an attorney that would have done all this for me because I'd be like, you know best. Let's do this. 8 to 4, she was yes, she was Starzy. 8 to 4 was what she was told with the computer.
copy evidence, because when the laptops are in quote, the laptop's in quote, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the
That's
opportunity
it.
to review the
That's
motions.
it. That's what he told her.
Neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything.
But you're not.
But I just wanted you to know that.
You've made it difficult on yourself.
To also be looked over.
Okay.
9/17, if that has to be changed, and I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review
2 weeks.
the physical evidence. You'll be provided the digital evidence, it seems, in advance of that
Yeah.
September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
Yes, he did, Starzy.
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay.
I don't think it's a matter of her not wanting to use the computer. She believes that the computers have been that she doesn't have direct access to it or that other people can view the documents. Doesn't matter. At this point, it doesn't matter. Like none of it matters. All she has to do is review the documents. All it is a delay tactic, and the judge is done with her bullshit. He made that very clear in his last order by so many words of saying, yeah, we're moving forward. This is the date that you've got set, and you're going to just have to get your shit together before then. Like time to play is over. You've been playing with the court for the past 4 years. 4 years. This happened in 2020. Here we are in 2024, and she's just now finally getting the trial. And this is not because of the judge. This is because of her actions. Yeah, this is all on her.
I'm very weary to make these type of deadlines.
But we're setting them today,
I understand. So the 3rd is a what day? Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court.
Anytime after that, you're
2 weeks later,
screwed.
We would need to have a hearing on those objections. We would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
So if she wanted to have any objections, she has to have those filed. If she files them at the very last minute, as long as whenever they show up to that hearing, that they've been filed, even if the court hasn't received them yet, she can bring those with her physically, and she can say, this is what needs to happen. This is what needs to be shown. These are my objections. The judge on that date, he's going to look at all the objections she has, just like he's getting ready to do. He's going to rule on those objections one way or the other, or all of her motions.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that
Yes.
in every way, shape, and form by September 26th in order to go to trial for October 7th.
Yes.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So basically, the judge has said, we're done playing around. You've been playing around with your attorneys for the past 4 freaking years. This could have been settled much earlier. We could have had a trial date much earlier, but because of you being a difficult and a very litigious person, this is the problem that we're having. This is why it's taking so long. And the judge is done. He's like, I'm getting this moved off my docket and we're moving forward. If you don't like the speed at which we're moving, then you need to file motions and I'll rule on them. But he's done playing.
So by me not even seeing my discovery yet 2 days and only being restricted to a laptop on page 4 and not.
That is your problem.
Hard copy evidence.
You have 62 days
That-
to prepare for trial, not including today. And you're going to get your
Now, pay attention to that. That's 62 days for her to prepare for trial. 62 days, 8 to 4. That's right there is more hours than any single attorney on her side has put into this case. She drives me nuts because she keeps asking the same question different ways over and over again. I know, CJ. That is the biggest problem with her is she will ask the same question over and over. The judge is very accommodating. He answers her. He's like, it is what it is. And we're moving forward. You've got 62 days. Whenever we walk out of here, whenever you walk in there and you've got that little USB and you're sitting there watching, going through your evidence, you're going to have 62 days to do that. There's not much more you're going to find in 62 days. That's over 2 months worth of you being able to sit there, write down any objections that you have, file those with the court, and just move on and continue on. I have a feeling that she is not doing that. She's being lackadaisical, and this is what her problem is. She's not paying attention to what is going on around her. She's not paying attention to what the judge says. He has to explain it to her multiple times. She's a difficult litigant. But they'll get that straightened out.
your discovery today.
There we go.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
Yes.
I'm not going to answer that question.
Nice.
And I said, this is
What now we're addressing, ma'am, is September 17th.
right.
Yes.
Deadline, which is 2 weeks after having the physical view of any of the physical evidence.
Oh,
It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll
this
have
is
plenty of
almost
time
like
to
dealing with
review
someone
that
in divorce
in
court.
2 weeks at a minimum, or 2 weeks at most, rather, to lodge
Yes.
objections to the physical evidence.
I understand. I just don't understand how to file.
None.
I cannot answer that for you. That would be me
There you
providing
go.
legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
There you go.
Okay. And if I may ask, Are these being delegated or I'm being incorporated in this in order for me to be able to say yea or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
See, this is what I know what she's trying to do, what she's trying to bring up. Well, you took away my counsel. I didn't ask for you to take away my counsel. The judge's response to this every single time is there was a 16-page order that explains in detail, in very vicious detail, why you are representing yourself. This was a choice you made by your actions. No different than the choice you made by your actions whenever you didn't let that man out of the suitcase. And the judge isn't going to play her game at all. He's going to say, listen, sweet cheeks, we're moving on. What's past is past. You're not going to be able to go back and revisit why. You're not going to be able to revisit any of the other shit that you want to bring up. What we are talking about right now, sweetheart, is this is where we're at. It's you've reached the point of no return. You've hit the point of no return. We're not turning back. We're not rolling back the clock. We're not rolling back the truth trolley. We're not rolling back anything. We're not stopping to accommodate you. The only accommodation you're going to get would be no different than we're doing with anybody else. So you coming back complaining about how many days you have left, you're going to have to rush to do it. We've already addressed that. That's already been addressed in that 16-page order that was signed by me. Done. Done playing. These are the consequences of your actions. This is what the judge is saying without having to say it, is we're moving forward, whether you like it or not. I'd like to see this judge with Lynette in Ocala, Florida. Oh, yeah, that would be amazing. Living County. Yeah. It would, and he is being very patient with her. Oh, so patient.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with that, with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet. Your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have
Your
been pro se
comfort,
before and do not.
your comfort does not matter. It does not matter what you're comfortable with. This is where we're at. Little team, my husband would constantly break my things and say it wasn't intentional. That phrase triggers me big time. Yeah, I understand. I hate that crap. I understand. Wasn't intentional. Mm-hmm.
Not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also if you are proposing that I go to trial within 62 days that
Again, this was addressed earlier, sweetheart. I mean, I am surprised. The judge's patience is so astounding, because I would, if I were that judge, I'd want to jump over that bench. And that's what she's doing. She is trying to push him into saying something that's inappropriate or not true. And he's giving her the chance to speak. He's dealing with it. Your time, you're wasting. Waste as much time as you want. The court is steadfast in what it's saying. Judge Nate Job. It should be. No, it's Michael. Oof.
I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone.
Doesn't matter. That time has passed. That time has passed. Move on. Move on.
Else if they just delegated the date and gave me a printed copy with your order.
Yes, unless you can provide a reason why those dates don't work for you. then we're moving forward. So bitching and moaning about not feeling comfortable or some crap like that doesn't fly as a reason why. I mean, a reason why would be, I've contracted the COVID. I'm sick. If I show up in court, that could cause injury to other people. But you would have to put that in a pleading. And then the judge has to hear the pleading and say, well, are you going to be over it by then? Just because you have it now doesn't mean you have it then. So she's got nothing. She's got nothing. This is what it looks like when someone has been given all the rope they need to hang themselves. That's all that it is.
Whatever information you have, I don't know. I don't know either if you all are just proposing that.
Doesn't matter.
Just the dates are what you tell me. I don't know what I'm doing. I don't know. I do not know what
Yes.
I'm doing. So I'm trying to learn.
Judge warned you of this. It is 16-page order.
For me to accept this date and then not be able to meet it. What happens when that happens? If it should happen.
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
I mean,
You're an idiot.
I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address the deadlines for any exhibits or witnesses that you may be.
Oh, well, hopefully that goes
I am
well.
hopeful that you will be receiving the discovery today, and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours.
That's not what the judge asked you. That right there is not what the judge asked you. The judge asked you, at this point, is there a deadline that you need to set? I don't care about your excuses. I don't want to hear the dog ate your homework. I don't want to hear none of your shit. All I want to hear, sweetheart, is there a date that you want to set, that you want to have everything handled by? Again, her ability to not pay attention to what is being said to her astounds even this judge. This judge is probably sitting there going, damn, sweetheart, you did not listen to a word I said. I'm giving you an opportunity here. Giving you opportunity to not be a dumbass. And again, you've taken that opportunity to be a dumbass.
So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone.
Doesn't matter.
Telephone call that I do not have regular access to, and
Doesn't matter.
limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle, please, that I need you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses.
Sweetheart, this has already been judged on our previous thing. Reason, comprehension is lacking in her world. This is what alcohol does to your brain. This is your brain on alcohol. Stop drinking alcohol. If you want to have cognitive thought, then don't drink alcohol, or at least just pay attention. Even if you're going to drink to your heart's content. Sweetheart, the judge already has explained this to you multiple times. I don't care about the sob stories. Sob stories aren't going to work on me. We're done with the excuses. We're moving forward. What part of this do you not understand? What part of this do you not understand? I don't care that you can't contact people. I told you this whenever I told you we were going to remove counsel from you if you continue on. We're not going to keep appointing new counsel to you. You're going to be on your own. Yes, she was a heavy drinker. Heavy drinker. She got completely shit-faced the night that her boyfriend was locked in a suitcase That's why she's here in the first place. She went to bed, passed out. She's like, what? At the time, she was like 90 pounds wet, if even that. And she went through a bottle and a half of wine. Jeez. My wife, which is not that light, she's not 90 pounds wet. At one point she was, but she's not 90 pounds wet. But I guarantee you, she's not going to be able to go through a bottle or a bottle and a half of wine, or even a half a bottle of wine, and not be just like passing out. Yet and that's all she's doing. She's playing stupid.
May I ask, please, does
Yes.
the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Who is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
There you go.
May I ask your contact names from the jail?
What?
1 second.
Please, and also, because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? The protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol.
Oh, right here you go.
The deputy can deliver that to you right after. Did I do? Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So understanding
Microdot.
that as of right now, you do not have hard copies. You'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits
Oh, right back on task. It was just like, when do you feel comfortable providing witnesses?
that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to our regular phone. I need to look.
No, there is no to be determined. There is no to be determined. When do you need this done? Yeah, we've heard this before.
Locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything.
Yes, sweetheart, you're not going to be able to Google your answers. That if that's what you want, you're not going to be able to Google your answers. That's not the way this works. Sweetheart, the judge explained this to you. This is going to be difficult for you if you go pro se. Stop effing around with me, and you won't have to worry about this.
Because I do not know how I will be able to do any of that at this time.
Problem.
I would like to.
That's a you problem.
Your understanding of a meeting that I would like to have with the captain, so I can see if I can have access to a regular phone, if I can have access to an internet. Right now, I
No.
have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone, I don't have access to the internet.
You
That's
can
a you
certainly have those
problem.
conversations with the jail representatives.
That's
Ma'am,
you
we were
problem.
Notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Ma'am,
Now, isn't that awesome? The attorney, the attorney, oh, the guy that went to school, he understands. She cannot look up case law. Is that right? No, she can look up case law in the law library. That is provided to her. She has access to the law library, which she's been there for 4 years. 4 years of having access to the law library. What was she doing with those 4 years of time? What was she doing with those 4 years of time? Couldn't shut her fucking mouth. I guarantee it. Yeah, they have a library right there in prison. She has a tablet that has access to it. She can look up anything. She could have used every single bit of her attorney's time for them to explain all of this stuff to her, but they're like, yeah, that's not what we're here to do. We're not here to explain it to you. Like I said, difficult. This is what she had to do.
Are you amenable to that? That 14 days after you've had the opportunity to review the digital evidence?
Honest question. Are you amenable to this? Are you ready for it?
And 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these things which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated.
Nobody gives a shit about your circumstances. Nobody. Judge doesn't care. I don't care. The attorneys don't care. You don't even care. You're just using this as an excuse to delay. Well, you're going to get your day in court, whether you like it or not. Judge is done playing.
And not having access to them, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14
Yes.
days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity?
Yeah, the judge just from the bench right then and there ruled on it. It was just like, she has not provided any reason why those dates are not amendable. So if she doesn't like these dates, oh well, that's just tough. That's what's going to happen. Just a second. Be right back. I love it whenever I have things running in the background that make noise. What exhibits can she even have? No, she could choose to present whatever exhibits are currently in the state's possession. Use them as a defense. Say, for example, she had an exhibit that showed that she wasn't there physically. She could say, listen, right here, I have evidence that shows that I was not physically there. There was no way that this could have been me. That was somebody else that was pre-recorded. And I wasn't even there because here's the receipt from the bar where I was paying the tab at the time that you're saying this occurred. That's the kind of physical evidence she could have. That's part of discovery. That's what she's missing out on. Is all of that stuff's been provided to her. All the depositions of all the witnesses, character witnesses, all of that stuff is being provided to her. And they're saying 14 days after you're done, she hasn't provided a reason why the judge can't move this thing forward. Like I said, done playing around.
You review any of her exhibits.
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr.
Okay, all right. I will set a deadline for the review of September 26th.
Nice.
Is the review that you're seeking out, please, for my executive and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceeding?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have been done to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here. All right, very good.
So they're about to bring in somebody here shortly.
Go ahead and swear you in. You can stay to the podium, sorry. No, just the podium, Sergeant.
So this is the guy that she's been accusing
You
of
can raise your right
doing
hand, Madam Clerk,
things.
and go ahead and swear you in.
Sorry, I'm standing up. Trying to get a little bit of
All right, sir, good morning. Could you
blood
state your name
circulate.
for the record? And what's your position at the Orange County Jail? And what are your duties and responsibilities, sir?
Over transportation, downtown.
No, the guy that's on the big screen, that is JA. That's judicial something or other. It's they're there to provide assistance to her in the capacity that they're allowed to. So that's what that man is. He was there to basically bring the judge up to speed of how they were getting documents sent back and forth, how those things were happening. That's what that's why that guy is there in particular. So that's all that he's there for. Just that. That's it.
Airport holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I am.
Okay. Mr. Lane, can you come on up here, please, sir?
Come on, Mr. Lang, get up there.
Doesn't break investigation. Digitizing 2 bankers' boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time.
Yeah, it is.
Were you able to fulfill that task, sir? Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those, this drive
One.
here is a copy of all digital discovery that I have in my possession from this Boone, where the court's needs if they wish.
One jump drive.
Facilitate that through figure it'd be easier to facilitate it now.
One little drive.
Than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers' boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand-delivered by
2 drives.
to Sergeant Casey. So Sergeant Casey, if you please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey? Okay, sir, thank you very much. If you can proceed with that task, I appreciate it.
You do it.
Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him? All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocol as provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain Captain Via Giovanni that if she has time at some point, as soon as possible, please sit down with me for about a half an hour to go over quite a few things that I need to have resolved. Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 banker's boxes. Did you bring those back with you, sir? Okay, could you bring those back up?
Yeah, Richard Kahn's Beyond Fair. Yeah. So those 2 beggar
You
boxes
see, it looks
are
like the
what's on that
original
jump
tag is
drive.
still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes? Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task? All right, ma'am, do you have any questions with regard to your investigator regarding?
I
his
bet she
completion of
does.
the digitization process?
Is she silly?
My question is, Mr. Lane, do you know when you would be coming to meet with the Apogee?
It's gonna be my intent to try to get out there at the end of the week or beginning of next week.
And there was an issue with the actual feed itself. Comes back after a few seconds.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yeah, that would be acceptable. Yeah, if Mr. Lane, and you want, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think it makes sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, say, $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor. We will prepare the order and submit.
All right, very good. Just send it to Ms. Berrio, so I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir. All right. Yes, ma'am.
What is the same thing?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed.
Oh, it's already been stated multiple times who that guy is on the big screen. He's with the JAC. Sorry about that. Thanks, Roxanne. Appreciate it.
Notice of filing, if I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
There you go.
I would like to have some type of witness from
He will be
my
there.
side also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
So there you go.
Now, ma'am, you may
Already
have
been
some
told.
motions that you may have brought with you this morning. All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy.
They must have her handcuffed at the waist also, because she's just like she can't even reach her arms out.
To please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm gonna be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document, proposing the dates for today's hearing. And, I guess it's some type of notice. That's what please that she was going to print out to give to me, so I have that.
Jesus Christ. I've got an objection of something that was muted on this. I'm an idiot.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed. Can you print a copy? It should be in the file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
All right, he's going to review these motions.
As I identified earlier, there was a clerical error using the general PO box as opposed to legal.
That's already been addressed. So this is that 52-page letter that she had.
Remedy, but I don't have a problem granting your motion for the correct address for any legal mail.
All this is. He's reviewing all of her shit.
Seeking to use a laptop. I've written correspondence from you asking for a laptop.
Yep.
That laptop is being provided.
Yep.
At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in a female dormitory. You have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that
No, that's what those are the statements that you made, that you are so confined that you don't have any place to store these. Had you said, yes, I can store them under my bunk, they probably would have done it for you. But you, by your own admission, said, no, I don't have anywhere to store these.
I know that are in the court file that you've made. You've written letters requesting a laptop that's been provided to you.
Yep.
You have written letters now specifically asking for a laptop
Yes.
without me going through all the correspondence. But when
No.
we have our hearing on the issue of the your motion for freedom and movement, well, I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been.
That's your fault.
Also by Sergeant.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional.
No, you forced yourself. Get this correct. You have not been forced. You forced yourself.
Case documents at my bunk. Help me understand, please, for future reference, so I know how to approach.
No, that's not his job. That would be giving legal advice. You need to just do your job and stop with shenanigans.
By my statements that I made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery.
It is not his job. It is your job, sweetheart. You have to make the motions. You're saying you don't have privacy. You don't feel secure, that you're worried that your documents are going to get damaged, that you have no place to store them, that you just have this little bitty space to live in. I got a place to put a toothbrush, toothpaste, and tampons. That's the only place that I have. Judge is saying, well, if that's the only space that you have, you don't have any storage, and the jail has already said they don't have any place to put storage. By your own admission, you screwed yourself by being a pain in the ass.
I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation.
This is your own fault.
Close that laptop at 4 p.m. and then pick up the discovery of hard copy and the 2 boxes that I have. I haven't spoken to the captain
It's not going to happen.
The protocol for a laptop. I know that you had mentioned it to me the last time we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and.
You're confused that everyone else is confused, that you're confused about being confused. Stop with the stupidity.
Suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion.
He's not coming to any conclusion. By your own admission, you said X, Y, or Z. I don't have any place to store this. That's not a conclusion. That is a statement that you made, Sweet Cheeks. You were the one that said this. The judge is going by what you have stated. That's it. These are things that you're putting out as fact. This is the problem with being an idiot. Whenever you put things out as fact, you don't realize that you're putting them out as fact. Judge hears everything that you're saying. He can't answer half of the questions that you're asking him. He told you time and time again, you screw around with attorneys and running them off, we are not just going to give you a new attorney. At some point, the court has to move forward. And we're not going to waste our time on you being a dumbass. There you go.
The process was created, and I'm just reciting what you've said to me at prior hearings, man. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag, or property bag, that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those two bankers' boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form. It was in digital form. And that was the process.
There you go. This is why she screwed herself. Suck it up, Buttercup. Enjoy.
That the jail created, they are aware it's two bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
Except for her.
I was never asked anything. Just like my letters to you prior to you forfeiting my right to counsel, I was never asked.
By your own actions. Stupid. By your own actions. By your own actions. But we're coming on that point where we're going to be firing everybody over to the evening stream. This one is going to have to be continued tomorrow. Tomorrow, tune in. We will have the rest of this, hopefully with some better audio tuned in for you. But right now, I've got to go meet up with the rest of the boys so we can get everything set up. I want to make sure that everybody's got access, get everything loaded up, get the screens loaded up. There's a lot that goes behind the scenes. I don't want to just all of a sudden kick you over there. That's what's going to happen. You're going to be kicked over to where everybody's going to be tonight. This is going to be the place to be. We're going to have Valhalla Awaits. We're going to have MG Law. We're going to have the expert. Oh God, come on. You got to love the man. And then Fallstorm. I mean, with that voice, come on. This is going to be the best. This is going to be the best. We're going to do this here in about probably about 5 minutes. It's just going to, all of a sudden, you're going to get the exit and it's going to kick us out of there. But you'll see us over on the next stream just real shortly. I can't tolerate her stupidity anymore today. It is time to make this happen. You fine ladies, you fine gentlemen, just know that that's where we're going and that's where we're going to be. And we will give you this one before we kick you all out of here.
That shit was close, dude.
Hunter, what's going on right now?
We're getting shot at by single shot Freddy.
Who's that?
I have a feeling he's a blind Afghan man somewhere between the ages of 60 and 75 years old. And he likes to scare the shit out of us with these single shots that he takes. We've been getting real close, so we're all hiding right now.
How come you think he's blind?
Well, because he hasn't hit anything yet.